Sir, with your permissions,
yes,
we'll proceed this today's session. To all, I, Professor Dinesh Kotre, coordinator of 1 week online workshop on Indian Penal Code, warmly welcome to today's resource person, Honorable Dr. Prabir Kumar Pattnaik, sir, Senior Professor, SOA, National Institute of Law, Bhubaneswar, Orissa. I cordially welcome all the participants across India. I heartily welcome our beloved Principal Dr. C.M. Rao, sir. Today's resource person is going to enlighten us on the most important, intricate, and difficult topic to understand in IPC, that is culpable homicide and murder. I hope today's lecture will benefit us to comprehend the insights of this topic, that is culpable homicide and murder. Once again, I welcome you all on this fourth day of session in 1 week online workshop. Welcome to sir. Over to Prashasti.
Now moving ahead, I would like to take an opportunity to introduce our resource person of today's session, Professor Dr. Prabir Kumar Pattnaik, sir. Respected sir is a senior professor of law and former dean at SOA National Institute of Law, deemed to be University Bhubaneswar. Sir has glorified the various positions such as Vice Principal at Mayurbhanj Law College, North Orissa University, Principal at University Law College, Utkal University Bhubaneswar, Professor and HOD at PG Department of Law at Utkal University, Professor and Coordinator Master of Law in Human Rights at PG Department of Law, Utkal University, Professor of Law at KIIT Law School, KIIT University, Bhubaneswar. Not only this, Sir has also designated as a visiting faculty at various renowned law colleges of India. Respected Sir is a life member in Indian Criminological Society at Madras and also a member of Board of Directors of an NGO named PECUC Bhubaneswar, which is recognized by ECOSOC. Sir is associated with the Open Learning System at Bhubaneswar. Sir has a specialization in the area of criminal law, business law, and human rights. Sir has 32 years of experience with 5 published books, 18 articles in National and Scopus Index Journal, 23 newspapers, and 1 reviewer of foreign journal to his credit. Sir has also evaluated 25 PhD theses and 4 research projects. Respected Sir has received 14 awards during his PhD scholars. Sir, we are honored to have you today with us. Before we get started, there are a few instructions for all the attendees. Kindly mute your audio and the video so it could not create any hindrance in the middle of the session. If you have any queries, put it in the chat box. It will be taken up by the sir after the session. Now, I kindly request Professor Dr. Prabir Kumar Pattnaik, sir, to kindly take over the charge. Over to you, sir.
Thank you so much. Good afternoon, everybody, and those participants who have taken a lot of, arrangements to participate in the audio seminar. And at the outset, I would like to not only thank Professor D.B. Kulte, who actually invited me to deliver a lecture on a topic entitled Culpable Homicide and Murder. So I'm really greatly honored to deliver such a lecture in MP Law College. And I express my deep gratitude to Professor D.B. Kulte. But in the process, I came to know that Professor Dr. C.M. Rao is the team leader under whose command the MP Law College is in the process of development and excellence. So I also thank Dr. Rao, who is the principal of the institution, for giving me an opportunity. And I also thank Professor Dr. Aparna uh, Uttapalli, who is the IQS coordinator, and Professor Sri Krishnan Murray, who is the vice principal of the law school or law college. Okay. And I also welcome the learned participants who have come to listen me. It's been a long, journey as a law teacher, and since beginning of my career, this topic particularly, culpable homicide and murder, have uh, raised many questions, especially when I read in my, when I was a law student at MS Law College. In our time, we were asked to read and prepare notes and submit it. Some of the selective cases in which, in all subjects, we had 7 cases. And in particularly criminal law, we were asked to read R versus Govinda case. And we had moot courts on the subject also. And from those days, I had a kind of question which was raised by Lord Melville. And later on, I personally also wanted to understand the logical dynamics and logical considerations on the basis of which Melville could deliver such a wonderful judgment. Now, I will not go much in that direction. In the slide, of course, I apologize to the women participants, because in these pictures, one of the picture depicts about how a woman is being brutally murdered, and the other picture on the left, which is being shown, is also depicts about a murder which has which has been taken or is that offense is committed in our tribal areas of Odisha, and this death has been caused by the Naxals, and which is, right now the frequency has gone down, but few years back, every day in the newspaper you will be finding some incidents relating to the death or homicide caused by the Naxals. And possibly women are the worst victims in all cases of homicide. So this is the slide in which I wanted to present one thing. You might have seen this film, Kill Bill. Okay. You might have seen also Rakt Charitra 2. And all these blockbusters. What is so special about these films? You will be astonished to know that in the entertainment industry, whether it is television or movie or any kind of other mediums, it is interesting to note one thing, that entertainment industry earns about $12 billion depicting violent crimes. I remember when I was in college, I read a very prophetic statement given by Jack Anderson, a great American journalist. At that time, he predicted that in 21st century, people will mint money at the expense of the misery of others. And right now, we are really witnessing those kind of events taking places around ourselves. Now, in the television, every day we are exposing our young minds with respect to, and unless there is a violence, nobody wants to see movie. And somewhere I feel that killer instinct or violent instinct have dominated our taste. So this is a very disturbing development that has taken place in 21st century. Now, if you look at the frequency of crimes in India with respect to the murder, culpable homicide, death by negligence, road accident, dowry death, attempt to murder, miscarriage or infanticide, foeticide or abandonment. I'm very happy that in comparison to 17 and 18, the frequency of murder reported has slightly come down, but the statistics shows that the frequency of murder at all India level, these statistics have been collected from NCRB, and it is 28918, culpable homicide 3470, negligence 144842, the road accident 136587, dowry debt still persists 7115, attempt to murder 51254, and miscarriage and other forms of infanticide or foeticide is 1950. So this indicates that every year, of course, attempt to murder is a different area, but all other, if you put together, it still indicates that our people are violent people, even if we call ourselves as one of the most peaceful nation. But let me frankly tell you that it indicates about our violent attitude and violent conduct. We are not a peaceful country, or we are not peaceful people. Now, the next which I would like to present before you is that why people commit culpable homicide. Now, very, very interesting, sometimes it comes to my mind that if we kill somebody, we are being branded as a murderer. But the same man wearing a uniform kills another enemy, he is being decorated with medals and he is designated as a brave person. Okay, now why this dichotomy? That when you kill a person, you are glorified, and on the other hand, when you kill another person in another context, you are being labeled as a criminal and you are subjected to punishment. So we have our own reasonings of justifying a crime. So I wanted to know that what are the causes of culpable homicide, especially in the Indian context. So from the decided cases collected from the internet source, I could find 10 possible causes for which a culpable homicide takes place. That is personal vendetta or animosity, property dispute, love affairs or sex-related uh, issues, monetary and personal gain, dowry, terrorism and violent act, uh, witchcraft, political enmity, communalism, and the last one is caste and class conflict. So these are the major causes of culpable homicide. In, of course, uh, in each nation, you will find the priorities and preferences uh, depending on their national context. So it cannot be generalized as uh, that these are the only reasons for committing culpable homicide in any other country. So this set is in the context of India. Okay. So now, when we say that culpable homicide, what does exactly culpable homicide means? Now, if you look at the etymological interpretation of the term, it means homicide has a two-word combination. One is homo, the other one citadi. And if I analyze the word culpable, culpa means in Roman "aike," and culpable means in Latin terms unlawful. Okay. So when I say or you say that this culpable homicide, it certainly means unlawful homicide. And once we say unlawful homicide, logically it implies that possibly there are some lawful homicides. And if that is true, what kind of uh, homicides are lawful? In the screen, I have pointed out what are the unlawful homicides and what are the lawful homicides. Uh, Lawful homicides are divided into two parts. Those are excusable and one is justifiable. Now, sometimes my students also ask me this question: what is the difference between excusable uh, and justifiable acts? Now, the basic difference between excusable acts and justifiable act is based on the doctrine of mens rea. Now, in excusable act, the actors or the offender who has committed the offense is mentally is incapable of constructing the requisite mens rea. For example, say insanity or infancy. These people are incapable of constructing the requisite mens rea to convict a person. But in justifiable act, you will find there may be an element of mens rea. Sometimes we do these kind of acts like judicial acts and necessity, consent, duress, communications, trivial nature, private defense. We might be having that element of mens rea, but it is coupled with actus reus. Therefore, the burden of proof lies on us or on the accused person, because under section 105 of Evidence Act it says that in case of proviso or in exceptions, the burden of proof lies on the person who asserts that. Therefore, till we presume that or presume the existence of that fact, that act cannot be, considered as a justifiable act. Therefore, there might be, mens rea, but your act is justifiable under certain circumstances until and unless contrary circumstances is proved. Therefore, this is the basic difference between excusable act and justifiable act. Now let us come to another issue, that is Article 21 of the Constitution. Now, Article 21 of the Constitution says that no person shall be deprived of life and personal liberty except according to the procedure established by law. Now, this implies that it is the responsibility of the state. Basically, India is not only an egalitarian society, or the state not only profess that, but it is also a welfare state. And in welfare state, the primary responsibility of the state is to ensure security and subsistence. It doesn't mean that the state will spoon feed every individual or every citizen of it. But it is certainly a constitutional obligation under the directive of state policy that states should make adequate arrangement to provide means of subsistence. That is why the state or the government is making different kind of schemes to improve the quality of life of every citizens. But what is primary condition is life and personal liberty. So in India, likewise in internationally, if you look at the international document, Article 3 of the UDHR or Article sorry, Article 6.1 of the International Covenant on Civil Political Rights, you will find it clearly says that right to life, personal liberty, and security of person is inherent, to every, and it is an universal human right. And the state does not have any right to take away without legal justifications. Therefore, Article 21, then Article 3 of UDHR and 6.1 of ICCPR, all these international documents also aims at protecting the life of a human being. And life of a human being is considered to be very precious, not only in our life, everybody's life, and especially in a democratic country like India. And whoever professes democracy, if the state is unable to protect the life and security of a person, we do not think that such a state is a competent state. Okay. Therefore, in the Constitution of India, under Article 32, you find a right to remedy also. And in India, if the state wants to take away the life of even a criminal, the forget about presumption, that is a legal obligation on the part of the state that it must justify the reasons. Even in Bachan Singh case, Justice Bhagavati, in his dissenting judgment, has categorically said that when the state wants to inflict capital punishment, the burden of proof is on the state to justify the sentence also. And if the state is unable to justify the sentence, it has no right to inflict such punishment also. So anyway, let's not go into that direction about capital sentence. Let us stick to the topic. Now, we have a criminal justice system in India, and it has two modes: adversarial system and inquisitorial system. Of course, adversarial system is applicable. If you go to France and other places, you find inquisitorial system. And here in India, we follow two maxims. One is nullum crimen sine lege. That means no crime without law, and nolla pena sine lege. That implies in Latin, no penalty without a law. So what I'm trying to say is that in criminal law, whether it is for the defining an offense or a crime, or whether you intend to punish somebody or award punishment, there has to be a law, and without that, neither you can accuse somebody nor you can punish anybody. So that is the beauty, and a very beautiful presumption is that the general presumption is that an accused person is presumed to be innocent until and unless he is proven guilty. But in inquisitorial system, it is reverse. Okay, a person is presumed to be a guilty person till he proves his innocence. But this is not the right approach. But there are nations who follow in specific, of course, not in general, but in specific. Sometimes also we have also included that more specifically in dowry death or in rape. We have our own presumptions. Okay, till the accused person disproves that presumption of law. Therefore, but in criminal law, whatever our presumption, and when crimes takes place, we immediately blame police that possibly the rate of crime is not going up, the conviction rate is not going up, and sometimes we also blame our lawyers, even judges, that इंडिया में तो कुछ होता नहीं, आप कुछ भी कर लो, 2 दिन जेल में रहेंगे, उसका बाद निकल जाएंगे, ठीक है? तो what is the problem? Because murder takes place, culpable homicide, dowry, different kind of offenses takes place, but we are unable to control them. Why? Do we think that our system is not okay, or our credibility is questionable, or our efficiency is not at par with the other advanced countries? So I was thinking why we are unable to control these crimes, more specifically the offenses of the first order, like culpable homicide, murder, rape, and all that. I noticed few problems, and these problems I have pointed out. That's untrustworthiness of investigating agency. We don't trust our investigating agency. And what is interesting is that the framer of the Evidence Act, he also doesn't believe the police, and police is to operate with the strength of the evidences. But I'm very happy that in London, at least, they have started relying on the statement of the London police. And in London also, of course, now they are armed, but earlier, even the British police were not allowed to carry arms also. They had only baton. But world is changing fast, and right now they are allowed to keep also weapons. There is another reason, uh, is impossibility of procurement of specific evidence, hazards of reliance on circumstantial evidences, intangibility of menacing and hazards of drawing inferences, credibility of witnesses, and the test of beyond reasonable doubt also. And sometimes what I have noticed that the prosecution lawyer and sometimes the defense lawyer, they also change gear, and these are the reasons for which we find uh, difficulties to enhance the conviction rate. So we have to, this is a separate area which is to be discussed later, so low. Okay. Uh, so I will not discuss these aspects at this moment. Now let us look at the legal framework that covers the issue of culpable homicide and murder. Everybody knows because uh, you have already read. You possibly, if there are some teachers, they might be having teaching the subject, uh, that culpable homicide, murder exception, then culpable homicide of a person other than the person intended, based on the doctrine of transference of malice, death by negligence, dowry death, attempt, abatement of suicide, drugs, miscarriage, and injuries to unborn person, from section 312 to 316. Then exposure and abandonment of child under 12 years of age or concealment of birth. That is section 317 and 380. So these are the type of homicide normally are punishable homicides prescribed under Indian Penal Code. Okay. Now today's the context is, uh, what is culpable homicide as provided under section 299. Now, if you read the opening uh, section of section 299, it says that whoever causes death. Now, the definition of death has been provided under section 46. Now, if you look at the definition of death, the framer of the code, that is Lord Macaulay, I always admire that person. Very cleverly, he has omitted uh, or avoided the definition of death. And he says that the death of the death means the death of a human being. That implies that आप जो समझते हैं मैं भी वही समझता हूँ. डेथ का मतलब ये है. So I was wondering that why Lord Macaulay did not intended to define death. Of course, the time of death means very little in India, but for forensic reasons and for payment of compensation and other legal formalities in Western countries, you find time of death is very important. Therefore, previously, death referred means cessation of cardiovascular function of a human being. This was considered to be the accepted definition of death. Once your heart ceases, you are declared as dead. In defense, normally we were taught that how to know that whether a soldier or an officer in the battlefield is dead. So normally they say कि एक रुई ले लो और उसका नाक के नीचे the curve, a strand of cotton. If it oscillates, then you can know that breathing is on, but very feeble. Suppose the cotton strand doesn't move, then what is the next? Then you have to see the pulse just on the left side of the neck and check the pulse, whether there is heartbeat or not. If you are unable to read that, then there is another test. So you are to open the eye of the injured person and flash your torchlight twice. Okay. And if you don't have the torchlight, you can tap your finger, clean it in your mouth, and then tap and see whether the retina functions or not. And it is said that the retina is the most sensitive part of the body. And if the retina reacts or contracts and expands or dilates, there is a possibility of revival of the person, of the injured person. So that is how in the army or in defense services, without any technical, apparatus, in a manual examination, death of a person is determined. And this issue also came up that when we can declare a person as dead, whether the cessation of the cardiovascular or respiratory system. So in 1972, the Nature magazine, which is a world famous research journal, they had one seminar, international seminar, in which they were discussing the difference between brain and mind, whether brain and human mind are the same or integrated or they are different. So in the process, the issue was how and when the brain ceases its function. And from there, the question came up, the issue of death, when we can declare that there is a brain death. Okay. So ultimately, in 1975, the Royal College of England came up with this definition, which I have presented in my slide. And the Royal College, which is accepted also, it says that irreversible cessation of all integrated functioning of human organism as a whole, mental or physical. So that is the accepted definition given by the Royal College of England. Okay. So, but Lord Macaulay did not, rather refused to go into the technicalities of death, because in 1860 world was in a different shape. So that was the reason. But he could predict the contradictions that will arise when or while interpreting the cause of death, the nature of death or the definition of death. Okay. So absolutely in plain way, he interpreted the term death. Now under section 299, it says that whoever causes death, and death here means cessation of life, all integrated function. तो आपको मरना पड़ेगा. जब तक नहीं मरा है, तब तक कल्पेबल होमिसाइड नहीं होगा. Death is a precondition. ठीक है. Now the next line, it says that by doing an act, section 33, it defines about what is an act and omission. And this term by doing an act with the intention of causing death. Okay. Or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. It is interesting to note one thing, that in the defining section of culpable homicide, Lord Macaulay did not define what kind of act. In fact, an eminent scholar, I always admire that book, and I would certainly request the learned participants to have a go. Two books. One is by, that is of course 4 volumes, Penal Laws of India by Sir Hari Singh Gaur, and the other one is, Ross and Jones. That's a wonderful book on case and materials. But Glanville Williams is very interesting. Okay, so I will not again go that, but Sir Hari Singh Gaur has categorically have mentioned that there are different ways, different means and methods to cause death. Therefore, under section 299, he did not define the nature of your act. But before that, I want to explain you that what is an act? What is the classification of act? Can we say each of our act is criminal in nature? Can we punish for each act? The answer is no. Therefore, if you look at those books of Sir Hari Singh Gaur, he has given a table in which he has classified the act. Now, what is act? If you look at the definition of act, okay, you will find it says that it is exhaustion of will accompanied by physical action. Because human beings normally almost like a computer. They are not computers, but I would say brain acts as a biocomputer. You might have seen several films in which people are contemplating in future cyborgs, just like Arnold Schwarzenegger. And I thought about it, and I also agree with that human beings normally function like or in a binary model. You are all aware of the binary model. In our school, and those who are science students, you might have also read about Michael Faraday. Now, once Michael Faraday accidentally applied electric current to a dead frog leg, and he was amazed to see that the leg of the dead frog reacted to it. So he was, amazed and thought, how come the body is responding to the charge of electricity? And later on, we also realized that we are having a particular unit of our body is called brain. Now we have lot of neurons, billions of neurons. We have our own microchips, ICs, we have integrated circuits, all are biological in nature. But it is still unknown what triggers, what is that logical model, because in computer also the Microsoft, the Intel rather, it has developed machine logic. Today we are हर चीज में आज बोलते हैं ना, अलेक्सा ये जरा बताओ, तो ये वो machine learning है कि to understand the human language, the human logic and understand it. Let's not go into that direction. The basic is that in our human brain, the neurons normally program and they discharge the directions, almost in a binary system, 0 and 1. And these bioelectrical pulses are discharged from human mind, which is carried out by our nervous system, and ultimately our muscles respond to those binary codes. Okay. So basically, ACT has two segments: positive ACT and negative ACT. The positive ACT is divided into again two parts: overt ACT and mental ACT. Then negative ACT is divided into two parts, that is legal or illegal. And the overt act is basically physical act and mental act. Of course, nobody can see it, but it is still punishable. For example, conspiracy. And overt act or physical act is again divided into two parts, that is transitive act and intransitive act. Transitive act means complete act, intransitive act means incomplete act, and we call it inchoate crime. And the complete act or transitive act is again, if you stretch the bandwidth of the transitive act, you find three elements. One is commencement, the other one is preparation, and finally it is commissioned. Therefore, when in the section 299 it says by doing an act, it certainly means both by commission and both by commission. Sometimes we also mix half commission, half commissions. Okay. Therefore, with different mode and modalities and means, we can cause death. And sometimes I also noticed, कभी-कभी भी प्रेमी भी बोल देते हैं अपना प्रेमिका को देख के कि एक नजर मुझे भी देख लो, हमारे भी जान निकल जाती है, ठीक है? So romantically we can also express in that way. It is not always that तीर या खंजर आपको चाहिए किसी को मारने के लिए. अगर नजर भी डाल दो आदमी मर जाता है. On the lighter note, I just gave you an example, but there are different ways and means to kill a person. But we are not bothered about, not exactly totally, we are not bothered, but let us not get connected with type of act. What is important is with the intention of causing death. There has to be a causal connectivity with the intention, with act, and finally the consequence of the act. That is important. And if you look at the framework of culpable homicide, murders, and in the exception, there are three matrix, three type of matrix that are being applied. In culpable homicide, number 3. In murder, number 4. And in exception, number 5. Okay, 3, 4, 5. These are the matrices or the elements of section 299, 300, and its exception. Okay, now let us come to another aspect. Now, mens rea in culpable homicide. What are the basic elements that is required? One is that an intention to cause death. Number 2, intention to cause dangerously or dangerous injury. Number 3, knowledge that death is likely to be a result. Number 4, motive cannot become the basis. And on many occasions, the students get confused between motive and intention. But under Indian law, motive is taken as ulterior intention, and motive cannot become the basis of criminal liability. It is always under the common law or under criminal law. Mens rea is the basis of criminal liability on the first priority. Sometimes we also consider that actus reus has become the basis of criminal liability. Okay, so motive as such in India, but motive plays a very dominant role or significant role to understand the color of the intention, and it helps the judge while calculating the quantum of punishment the judge wants to award to the accused person. The proof of motive strengthens the certainty, and this case, Dalbir Singh's case, if you read that, you will find the dynamics of motives and how it helps the judiciary to come to understand the degree of certainty in a particular case. Now, as I said, I will not repeat, but just what is the definition of act? Exhaustion of or triggering of will, accompanied by physical action, either to commit or omit. And there is also an element that is will. Will is the volition of mind with an element of mental judgment. And free consent is one of the manifestation of will. That is also part of, but interestingly, there are certain offenses. Generally, we consider the mens rea of the accused person, but there are certain offenses where the legislature have ignored the will of the accused person, like in statutory offenses like kidnapping or in rape. The court considers the mental element of the prosecutrix or victim of the crime, but it does not look into the guilty mind of the accused person. Okay. Now let us come to the another. What exactly the intention? Because intentional death is considered to be a murder and also a culpable homicide. And all of you know that culpable homicide is the genus, and it is murder is the species. Okay. Now, to understand intention, I would like to quote Sir James Stephens in his book History of Criminal Law of England, Volume 2. Intention is the direction of conduct towards the object, chosen often considering the motive which suggests the choice. Whenever we decide or when we decide to act, just like madman or just like a child, we do not want to do things. We select, we choose, that whether we should do or not to do. We have our objective, our preferences, and it is a motive always that triggers a human being to stimulate and choose that objective. And in contemplating that, we might consider several other aspects. Because if I wish to kill somebody, my reasons would be different than others. The motives are different. The means are different. Therefore, mostly it is a question of fact. That is why in interpreting intention, there are three ways of doing things, interpreting the intention. One is the subjective analysis. The other one is objective analysis. And the last one is hybrid. That means mix of subjective and the objective. And if you want to read more about the subjective analysis and objective analysis, I would suggest to read Virsa Singh's case, in which Justice Sir Vivian Bose has very beautifully elaborated the subjective analysis and the objective analysis to come to a logical conclusion as to how to find out the intention of the accused person. Now, there are 3-4 important cases, English cases, which I would like to point out. The first case is Director of Public Prosecution versus Smith. This is the 1961 case. This is, House of Lords case. Now, in this case, the court held that the test that a person was taken to foresee and intend the natural and probable consequence of his or her acts. Now, a reasonable person, a normal person with ordinary intellect or intellectual capability, we all know that we not only know the nature of the act that we are doing, we also are aware, or we can foresee the consequence of the act. And of course, there are certain exceptions. आपने कालिदास का सुना होगा, जिस डाली में बैठे थे उसी को काट रहे थे. सिर्फ कालिदास नहीं है, हम लोग भी वैसे हैं. On many occasions, if I ask a married person now, कि भैया और एक बार शादी हो जाए, तो बोलेगा नहीं यार, एक बार बहुत हो गया. And prior to his marriage, he was very much interested to get married. ये क्यों होता है? Because जब शादी नहीं होता है ना, आदमी को बहुत कुछ एक्सपेक्टेशन रहता है, फैंटेसी आ जाता है. We glamorize, fantasize about marriage, but later on, what happens? We not only understand the hazards of marriage or whatever it is. Some people also know they have good life, but we know the consequences of marriage. Sometimes हम लोग साइकिल लेके, भाई का साइकिल लेके कभी-कभी गए होंगे without the permission of our elder brother. पहले तो सोचते होंगे कि गाड़ी ऐसा चलाना पड़ता है, साइकिल ऐसा है. It is easy, but later on we realize कि वो इतना easy नहीं है. Consequence are dangerous consequence. और अपना जो ये है, तो तभी लगता है कि नेचर तो जानते हैं, कॉन्सिक्वेंस जानते नहीं है. ठीक है. So, in Director of Public Prosecution Smith case, the House of Lords developed a presumption that every ordinary person with ordinary intellect or intellectual ability knows or can foresee the natural and probable consequence of his act. And if that person is capable of doing that, then we can say he did the act intentionally. In Hayam versus Public Prosecution 1974, another type of interpretation was, which was later on, overruled partly by Moloney case and Ulin case. Now, in Hayam case, the court held that the consequences must be highly probable. If the offender knows the probability of his act, or if he is aware that it is highly probable that this consequence will follow from his actions, then we can say it is an intentional act. But later on, in R versus Moloney 1985, the court modified and say that no, it is literally the court, uh, reverse back to Smith's position and said that it is practically very difficult to find out or gather the intention of a person from the highly probable angle. So the police or the prosecution will find it difficult to prove that whether the consequence is highly probable or not. Therefore, again, in Ulin case, it was held that let's not find intent, rather let us find intent rather than inferring intent. Because if you start inferring the intent, there is no end to it. It can lead you to. So the intention of the accused persons are not to be inferred, because inference has no ending. Now, sometimes we think that intention and voluntary act are same thing, but it is not so. All intentional acts are voluntary, but all intentional acts are not. The best example is Section 94, in which a person might do it something voluntarily under duress, but it appears that as because he has done it voluntarily, it is his intentional act. But technically, it is not. It is only a voluntary act, and it is not his intentional act. There are certain rules of voluntary act, and this voluntariness has been borrowed from the English principles of willfully. It is based on the maxim that a man is presumed to intend and know the natural and probable consequence of his act. It gives a constructed meaning and not the ordinary meaning. It has been defined with respect to the causation of effect and not in reference to the volition. Acts over which a person has no physical or mental control are not voluntary. That is why all intentional acts are voluntary, but all voluntary acts are not intentional. Now, in defining the voluntary act, we normally take different kind of test. One is express intention. The other one is implied intention. You have another term called knowledge. And in knowledge, sometimes we get confused about what is the difference between intention and knowledge. Basically, intention is the mental contemplation to commit an act whose consequences have been contemplated by you prior to the commission of your offenses. Okay. Sometimes we contemplate something, the consequences are something. Sometimes the consequences are different, but our contemplation or mental contemplations are different. In knowledge, when we talk about it, is the awareness of the consequences of act, even though he may not intended it. So knowledge refers to two aspects: knowledge about the nature of the act and knowledge about the consequence of that. The best example and citation leading case on the subject is Seras versus D. Rajan, 1895, All England Reporter, page 1167. Therefore, intention and knowledge are two concepts. If you know the nature but you do not know the consequence, then you simply have the knowledge about one aspect of your act. Sometimes you do not know the nature of the act, but you only predicted the consequence of the act. It implies that you know the 50% of the information on the basis of which you have committed the act. So that basically that is the difference. Now there are uh, some of the explanations you will find that is under section 299, explanation 1. A person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused his death. Now, just mark the terms in red letter, red color. And explanation 2, it says that where death is caused by bodily injury, the person who causes death, causes such bodily injury, shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented or averted. Okay. And explanation 3 says the causing of death of child in mother's womb is not homicide, but it may amount to culpable homicide to cause the death of a living child if any part of that child has been brought forth, though the child may not have breath or been completely born. Now, these terms, laboring under disorder, disease, or bodily infirmity. Now, these three terms are significant terms. During our student days, we did not bother about these terms. Now, what is a disorder? Disorder, a derangement or abnormality of function, a morbid physical or mental state. The way it should function, okay, it doesn't function. In our body, there are certain physical or mental state uh, that function in a logical pattern or logical order. ठीक है? Bones, muscles, ये सब एक functioning style, एक system है. उस हिसाब से हाँ, there are abnormal people who can also do very wonderful physical movements. Those are exceptional people कि अपना पाँव को बिल्कुल 360 घुमा लेते हैं. लेकिन if they are capable of doing that also, in circus also, they do different kind of gymnastics. They must have practiced so many times to show that disorder. उसमें भी कभी-कभी वो मसल्स डिसऑर्डर हो जाता है, ठीक है। सो डिसऑर्डर मीन्स a system which was given to us, to the human body, under a natural circumstances, for some reason is not functioning the way it should. जैसे कि ब्रेन का फंक्शन हुआ, एक ब्रेन एक सिस्टम है, एक फंक्शन करता है, वैसे फिजिकल उसका एक मूवमेंट है, उसका एक डायरेक्शन है, मसल का लिमिटेशन है, उस तरफ से फंक्शन करेगा। बट व्हेन यू समथिंग रॉन्ग इन दैट, देन इट इज ए डिसऑर्डर। कभी कभी तो सिस्टम डिसऑर्डर होता है, जैसे हम लोग बोलते हैं ना, ये पागल है, व्हाट्स रॉन्ग। कभी कभी हम लोग बोल देते हैं कि वो इसका आईसी खराब हो गया, ब्रेन खराब हो गया, ब्रेन डिसऑर्डर। और हम लोग का बॉडी में डिफरेंट सिस्टम्स है, रेस्पिरेटरी सिस्टम, कार्डियक सिस्टम, बहुत digestive system, and in explanation when it says that a person who causes bodily injury to another who is laboring under disorder, मतलब ये एक disadvantage। Secondly, और एक term है disease, any impairment of normal and physical function affecting all or part of an organism, especially specific pathological change caused by infection producing characteristic symptoms. In simple way, disease कब होता है? There are two ways of and two ways and means to contract disease. एक तो वायरल होता है और एक बैक्टीरियल होता है, ठीक है। And both the, whether it is bacteria or virus, it impairs the normal physical function. Infection हो जाता है, and once there is infection, it malfunctions and it significantly alters a system. जो डिसऑर्डर हम लोग बोलते हैं ना, उस सिस्टम को इफेक्ट करता है, and in consequence a person can succumb to death also. In disorder also a person can succumb to death. And there is another term, infirmity, the state of being infirm, feebleness and imperfection or weakness, an unsound, unhealthy and debilitated state. कभी कभी infirmity old age में भी होता है, जैसे कि मैं एक बुढ़ा बन गया हूँ, तो I cannot run at par with you. You people are young people. मेरा लड़का जितना काम कर सकता है मैं नहीं कर सकता। Sometimes हम लोग बोलते हैं ना, बुढ़ा सठिया गया, लेकिन ये इन्फॉर्मिटी नहीं है, ये डिसऑर्डर है, ठीक है। Because I'm approaching towards senility due to old age. My hardware is not retaining and or have deleted or is corrupt or about to be corrupt. So infirmity refers to a state of being of infirm. देखिए हम लोग का बॉडी में मसल्स होता है, बोन्स होता है, और हम लोग खड़े हो सकते हैं, वेट उठा सकते हैं on the strength of the muscles. But I have noticed कि कभी कभी अपना घर में जो बुजुर्ग होते हैं ना, वो कभी कभी बोलते हैं कि बेटा ऐसा लगता है कि मैं पीछे नीचे गिर जाऊंगा, और वो चल नहीं पाते हैं, उनको पकड़ के लेना पड़ता है, ठीक है। तो when you take them to the doctors, वो पहले कान देखता है, उसका बाद देखता है कि ये whether the person is suffering from Alzheimer or not, तो फिर वो कान में एक बोन है, हॉर्सशू बोन, अगर कान का अंदर पानी सूख जाता है तो यू फील लाइक फॉलिंग बैक, तो आपको सिंडोपा और दूसरा कुछ मेडिसिन है वो डाल देते हैं, खाओ और मरने तक ऐसे ही रहो। दिस कॉजेस इन्फॉर्मिटी, जब भी बोन टूट जाता है तो आपका इन्फॉर्मिटी हो जाता है। बट लिटिल चाइल्ड are not called infirmity till they suffer from polio and other things. Okay, so in explanation, it means that a person who causes bodily injury to another, who is laboring under disorder, disease, bodily infirmity, and thereby accelerates the death of the other, shall be deemed to have caused. जैसे कि मैं बता रहा हूँ कि आपका अगर स्प्लीन इन्फ्लेम्ड है, तो स्प्लीन हो या पैनक्रिया, आई एम टॉकिंग अबाउट पैनक्रिया, अगर इन्फ्लामेशन हो जाए तो आपका वो पैनक्रिया इतना सेंसिटिव हो जाएगा कि मैं अगर एक मोबाइल का साउंड उसको सुना दूं ना, द पेशेंट विल से प्लीज डोंट गिव मी अ कॉल, इट गिव्स मी पेन बिकॉज इट बिकम्स सो सेंसिटिव। अगर आप कभी वैसे पेशेंट को देखने गए हैं, वो आपका एनिमी है, तो आप चले जाएंगे हॉस्पिटल में और उसका पेट में आप थपथपा देंगे कि पार्टनर कैसे हो, उसका तो जान निकल जाएगा, he will be dead. That means you precipitate, you can precipitate or accelerate that death. कभी कभी फिल्म में देखते हैं ना, सीढ़ी का ऊपर से नीचे डाल देते हैं, वो जानते हैं कि चल नहीं पाएगा, ठीक है, किसी को सुनाई नहीं देता है, तो उसको लेके मेन ट्रैफिक में छोड़ देना। So sometime the killing can take place like this to a person who is laboring under disorder, disease and bodily infirmity. और explanation 2 में और एक चीज है कि कभी कभी the accused might take a plea कि अगर वो victim को या the person who has succumbed to injury, अगर उसको अच्छे हॉस्पिटल ले जाते तो बच जाता, and as because they wanted to prosecute me, implicate me, उन लोग लिए नहीं। तो ये जो presumption है कि although resorting to the proper remedies and the skillful treatment, the death of the victim could have been averted, ये logic accused का favor में जाता नहीं है, ठीक है। And the last one is causing, और बचपन में हम लोग जो स्कूल में थे if you kill a pregnant woman, it is double murder. But जब लॉ पढ़े पता लगा कि नहीं, it is not double murder. Both mother and child are considered as one unit. But it may amount to culpable homicide to cause death of a living child if any part of that child has been brought forth, though the child may not have been breathed or completely born. I come from a tribal village, and possibly we are the only non-tribal family in that village. I will just share one experience with you. कि उनका जो ट्राइबल फैमिली में they are quite liberal, और शादी से पहले उनका रिलेशनशिप हो जाता है, तो on one such occasion the girl become pregnant. बाद में पता चला तो गांव में तब I'm talking about 1958 and 59, I was very young, तो पूरा याद नहीं है लेकिन I remember the case, और बाद में I heard the entire story from my mother and my grandmother also, what happened to that case. तो तभी जरा शर्माते थे, and it was made punishable to terminate the pregnancy. तो गांव में क्वक्स होते हैं, तो तभी 3 महीना हो गया तो ये गांव में जो जो क्वर्क था, लेडी क्वर्क, उसको बुलाया, एंड द वे दैट लेडी क्वर्क टर्मिनेटेड द प्रेगनेंसी, तो एक दाव लेके ना, छोटा वाला दाव लेके ना, शी इंसर्टेड हर हैंड, और उसको दारू पिला लिया पहले, हाँ, विक्टिम को, और वो चाइल्ड को forcefully she brought to the main passage, and as because the child did not come out, तो छोटा छोटा पीस काट के उसको निकाल दिया, बाद में वो कपड़ा उपड़ा सब बांध दिया और फिर दारू पिला दिया। तो पहले तो उसका माँ को कुछ पता नहीं चला, हाँ, कि whether she is alive or dead, बाद में लगा कि नहीं, she is about to die। और इन दोज डेज गांव में तो गाड़ी वाड़ी होती थी नहीं, सिर्फ अपना एक स्टेशन वागन था, वो 1945 का, हाँ, तो हर मदर केम रनिंग एंड टोल्ड की मेरा लड़की मरने वाला है, आप कुछ कीजिए। तो माय ग्रैंडफादर टुक हर टू द मेन डिस्ट्रिक्ट हॉस्पिटल, एंड द डॉक्टर सेड, I cannot do anything, she will die now, and in fact she died। So this provision not only covers the foeticide cases or जो आर्टिफिशियल टर्मिनेशन ऑफ प्रेगनेंसी, आजकल तो एमटीपी एक्ट में वो लीगलाइज हो गया है, लेकिन पहले नहीं था। सो लॉन्ग द मदर एंड द फीटस आर इन वन यूनिसन, या एक एंटिटी में है, तब तक ये डबल मर्डर नहीं होगा, ठीक है। बट इफ यू ट्राई टू puncture any part of the uterus and try to bring any part there of the child, whether he is completely breathe or alive or not, it hardly matters। But if you take any part of the fetus and it has been brought forth, that means जो vaginal passage जो है, उसी से अगर आप discharge भी कर देते हैं, या any part thereof you are bringing out, then it amounts to culpable homicide। but जब तक ये नहीं हुआ है, वो culpable homicide एक mother का होगा, not the child। but if you try to separate both the things, both the entities, then it will be considered that the death of the mother and culpable homicide of the child। Now let us there is an important aspect that whenever we say that an accused person intentionally committed the culpable homicide, whether it is murder or not, what are the preconditions? How we know that the incriminating act is an intentional act or not? Death of a human being is a precondition, which I have already said. Not enough unless culpability of mind is established। ये जो निर्भय सिंह का केस जो है 1972 क्रिमिनल लॉ जर्नल का, हाँ, ये बड़ा इंटरेस्टिंग केस, और उसका बाद the other cases, जोगिंदर सिंह and बासप्पा, and there is an American case, जुत्सी जॉनसन also। तो एक बार पंजाब में क्या हुआ कि नहीं, a person, I call him a debtor, वो पैसा कुछ लिया था, वो पैसा रिटर्न किया नहीं, तो एक्यूज पर्सन और उसका जो टीम मेंबर है एक दिन उसको पकड़ने की कोशिश किए, तो दौड़ के भाग गया, ठीक है। लेटर ऑन दे कुड नॉट ट्रेस द पर्सन, so they possibly thought कहीं भाग गया, लेकिन सवेरे जब उन लोग तो लौट आए, बट सवेरे से पता लगा कि there is a dead body floating on the dug well, ठीक है। तो बाद में पता लगा कि जिसको the person they wanted to catch it, that data, he was found dead. The police came and arrested them. But later on, it was found from the existing evidences that neither the accused persons nor the victim were aware of a dug well. रात को उसको पता नहीं लगा, वो एक गन्ने के खेत में घुस गया, उसका बाद वो डग वेल था, तो उसी में वो गिर के मर गया. ठीक है. So sometime, and in that case, the court held that there has to be a causal connectivity between the act and the mental state. And unless this is a causal connectivity, we cannot attribute culpability. Because एक साइड में एक्ट होता है, दूसरा मेंटल स्टेट. अगर मेंटल स्टेट नहीं है, and unless the statute specifically prescribes, और एक रूल ऑफ इंटरप्रिटेशन जो बहुत इंपॉर्टेंट है, which everybody must know, whose the rule of interpretation of penal legislation says that whether this statute or where the statute expressly or by necessary implication has eliminated the element of mens rea, the liability is strict liability. Because we all know that in criminal law, the general principle is without establishing the mens rea, we cannot punish. Actus non facit trium nisi mens rea. And if the statute has, or the legislator has excluded the element of mens rea, like kidnapping, whoever entices and takes, it doesn't speak about the mental element of the accused person, okay, nor the victim. It clearly says that if you commit the prohibited act, you are punishable. Therefore, unless the statute, even if you look at the two interesting cases, Prince case and Tolson case, in Prince case, Prince was convicted because on the strength of actus reus, because the statute did not prescribe this, he was convicted, whereas Mrs. Tolson was exonerated from criminal liability because of the element of knowledge. Okay, so knowledge is a form of, it signifies a mental state, and it was required by the prosecution to prove that. Therefore, she was exonerated from criminal liability. It is immaterial if the accused person whose death has been caused is not the very person to whom the accused intended to kill. Sometimes what happens, we try to kill, we intend something, but our actions kill somebody else. Sometimes what happens, clever accused person can go for oblique intention also. वो कहते हैं ना, कहीं पे निगाहें हैं और कहीं पे निशाना. Very interestingly, a case which speaks about oblique intention. A shoemaker wanted उसका business चला नहीं, so he wanted to get some insurance. तो एक consignment में पुराना जूता वूता डाल के एयरक्राफ्ट में एक बॉम्ब प्लांट किया और भेज दिया. So in the midair, it exploded and killed not only the pilots but also the crew members and passengers. The police investigated, and later on it was found that the shoemaker planted the bomb in the consignment, to which he agreed and confessed. So when police asked that why you placed the bomb, he said, my intention was to only get insurance amount and not to kill the other persons. So now he sounds very ridiculous and pagal jaisa logic hai, irrational logic, that I wanted my insurance to get back, but I never wanted to kill. Sometime in section 301, we know what is transference of malice. There also, sometime we take the plea, I never wanted to kill that person, and unfortunately, a small child was killed. But here the issue is not the death of the person. It is immaterial. Who has succumbed to death? The issue is whether you had intended to cause death. If the intention correlates with the consequence, then the malice is transferred. You are liable for the, even though the consequence did not match with your act. जो काम किए उसका consequence क्या होगा उसको उस हिसाब से there is a mismatch. ठीक है? Let us go to sometime what happens, the connections are obscure. जैसे कि विजय बाई आपका महाराष्ट्र का केस है 1995, तो ग्रूम आया कैंसिल कर दिया अपना मैरिज प्रपोजल, तो वो मोहल्ला में रहती थी, तो कुछ लोग बोले कि मनोज लड़की है, and the bride committed or proposed bride committed suicide. So the question is, can we prosecute the groom that because of the groom's act the daughter died? Whether the connection between the death and the act of the accused person is obscure or distinct or concurrent. Okay. Sometimes there are very interesting cases. There are occasions where the causes are distinct, concurrent. जैसे कि सर्जरी किया, पेशेंट मर गया. कभी कभी डॉक्टर आते हैं, बोलते हैं कि सर्जरी करेंगे, लेकिन आते आते देर हो जाता है, मर जाता है. कभी कभी इनकॉम्पिटेंट सर्जन आ जाते हैं, ऑपरेट कर देते हैं, तो पेशेंट मर जाता है. सर्जन और पेशेंट डिड नॉट फॉलो द इंस्ट्रक्शन. कभी कभी सर्जन फॉलो नहीं करता, कभी कभी पेशेंट फॉलो नहीं करते. तो ये कभी कभी कुछ चीज है जो कंकरेंट कॉजेस है, कुछ चीज है डिस्टिंक्ट कॉज है. बट द बेसिक थिंग इज दैट there has to be a direct causal connectivity between the act and the prohibited actions. अब देखिए, डेथ कॉज्ड बाय वर्ड्स एक डिजीज है, एन्यूमरिज्म, जिसमें ये आप अगर पढ़ेंगे स्टीफेंस का एबनॉर्मल डायलेशन ऑफ ब्लड वेसल्स, तो कभी कभी अगर आप चिल्ला देंगे या हैरेस करेंगे तो आदमी मर सकता है, और उनका जो आरबीसी जो है आरबीसी डब्ल्यूबीसी जो है वो डायलेट हो जाता है. Those are rare cases, but by words also, कभी कभी if a person is suffering from weak nervous syndrome, आप झूठ मूठ का आप अगर बोल देंगे कि तुम्हारा लड़का मर गया या तुम्हारा वाइफ मर गया, out of shock also you can cause death by words. कभी कभी death can be caused without intention by doing an unlawful act. ये जो dog mauling case जो है of Noller and Noel, the owner of the dog instructed something to the dog, but dog responded in a different way and inflicted deadly injury. Sometimes death can be caused by omissions, and these omissions must be illegal, omission must be absolute. Premeditated omissions are murder, omission by negligence are manslaughter. So let me complete. There is also an element that injury. You will find section 299 and 300 also the term injury. Now, injury means what? Any harm done by a person by the act or omission of another. Injury may include physical hurt as well as damage to reputation or dignity, loss of legal right, or breach of contract. If the party causing the injury was either willful or intentionally causing harm or negligent, then he or she is responsible or liable for the payment of damages, or even he can be subjected to punishment. Now, one of the very important aspect of culpable homicide amounting to murder and not amounting to murder is basically designed on a mathematical model, that is theory of probability. Probability, everybody in your school you have read about theory of probability. It certainly says 50-50 chances of happening. Now, possibility and probability, there is a significant difference between probability and possibility. Possibility is less than 50% of chances. If you look at the picture, the diagram, and if we stretch the band from 0 to 100, the possibility of an event or likelihood of an event it starts from possibility. If it is +1, it proceeds towards probability. And once it reaches to the level of probability, it means there is chance of happening or non-happening is 50-50, but with a direction of towards the degree of certainty. Probability can be highly probable and just probable. When the probability is highly probable, it moves in the direction of certainty. And once it is highly probable, the degree of certainty is more. If you look at section 300, you will find in section 299, the probability is based on 50%. But in section 300, you will find the probability is more than the probability range. In the first order, in the second order, and in third. In the last clause, in the fourth clause, you find the word, in all probability it would cause death. Okay. And in clause 3, you will also find there is a in ordinary course of nature, the person is likely to die. And in clause 2, you will find that what kind of injury the assailant or the accused person inflicted and to whom the injury was inflicted. That signifies the selectiveness or the mental contemplation of the accused person with regard to killing or causing murder of that person. So therefore, when we say likely of, likely to, or whether it is injury or whether it is knowledge or whether it is an act, and its likelihood of causing death is primarily based on the theory of probability. I think I have crossed my time, so I'm sorry, I'm unable to complete. But anyway, some other time, if possible, we'll discuss the other things. But I would like to just, if my young students who are into the law and reading right now, sometimes it creates lots of confusion among the new law students. कि क्या जेनस क्या होता है, स्पेसिस क्या होता है, ये सारे के सारे. तो ये जो पिक्चर आप देख रहे हैं, एक तरफ he is a kind of primate. Actually, you will not find any difference between a human being and the gorilla. Okay, because same physical features. उसका एनाटॉमी almost same है, लेकिन उसका muscles and other things are slightly different. But we are Homo sapiens. We belong to the same, and these Homo sapiens have two species, एक मेल है और एक फीमेल है. तो ये culpable homicide है, and the features of culpable homicide is also present in the species like murder. But all culpable homicides are not murder, but all murders are culpable homicides. Or in other way, we can say all murders are culpable homicides, but all culpable homicides are not murder. Okay? Because the kind of features, if you look at कि गोरिल्ला में सब फीचर्स होता है, एक लड़की और एक लड़का, उसमें भी वही फीचर होता है, बट द ओनली डिफरेंस इज द रिप्रोडक्टरी सिस्टम जो स्पेसिफिक होता है. लेकिन आजकल साइंटिस्ट भी बोले कि नहीं, मेल का भी वो ऑर्गन है, बट इन ए डॉर्मेंट है. देयरफॉर दिस गोरिल्ला इज जेनस, these are the species, and we have another group called transgender group. These people might be having some characteristics of either the genus or the species, and those are special categories. Okay, there was the same way genus, species, and exceptions have been provided under section 299 and 300 and its exception. And this table you might have seen. So I will some other time, because it will take some time to explain all these things. So thank you very much. We are running out of time. Okay. Okay, thank you so much.
Sir, before that, I request you will have another session on next. I will inform you, because we have covered the 50%. The rest
yes,
is, yes, the second part.
50%.
Yes, we will arrange the second lecture, the second part also. But as per your time and all the time.
But because right now examination is going
Yes,
on,
yes.
so I could not, Professor Kolte, I could not say no to you. Okay, I love you so much. I could not say no. But if it can be arranged after 4 o'clock, but again that will, or this time, I may be able to take, क्योंकि by that time my examination assignment will be over.
Yes, sir.
ये
As per your
online-
as per your time,
हाँ,
as per your convenient dates with
अच्छा,
times and date
ठीक
with.
है, ठीक, हाँ, ठीक है, ठीक है.
Thank you, sir.
हाँ.
Yes. Precious, you over to you.
Anybody wants to ask any question, sir?
Thank you so much, sir, for enlightening us with your great knowledge. Now I request Professor Koltis, sir, coordinator of this online lecture series, to kindly take up the Q&A session. Over to you, sir.
Thank you, Precious. I hope no one has put a single question because you dealt in such a in depth because nobody dared to ask a question.
नहीं, ऐसा बात नहीं है. हाँ, सवाल होना चाहिए.
Well, well. Sir, there is one question from the Anvesta Murthy. One question is there.
हाँ सर, बोलिए.
Sir, can you please tell the sections of thermal injuries?
No, right now I have no knowledge about that. I cannot give you exact thermal injuries because as I understand, ये रेडिएशन के बारे में मुझे उतना जानकारी है नहीं. ठीक है. If he is referring to those possibly he is referring to radiation injuries.
Thermal injuries, sir. Thermal.
Are you referring to radiations?
Anvesta.
Hello.
Yes, sir. Yes, sir. She is saying yes.
Yes, radiation.
Yes.
Because I will not comment on the subject without proper references. Okay, that will be an unqualified statement.
Yes,
because I have not gone through or studied regarding thermal injuries. एक दो बार पढ़े थे regarding the Chernobyl जो disaster हुआ था, तभी उसके बारे में थोड़ा पढ़े थे. और ये रेडिएशन इंजुरी भी एक है. आप अगर पढ़ेंगे तो जो टॉक्सिक वेस्ट जो है, कभी कभी वो जो I discussed about concurrent and distinct जो causation जो है, तो sometimes subsequent connectivity वो भी culpability को indicate करता है. And in one case a truck was taking some toxic material. So due to the negligence of the truck driver, the toxic waste somehow leakaged from the truck, and a passerby, the, the driver did not know that it is leaking, but out of curiosity somebody was exposed to that radioactive material and ultimately suffered, and after a period of time he died. Now the question is, this caused, the toxicity caused the death, and initially we cannot attribute the negligence is directly attributed to the accused person or not. But in that case it was attributed, he was not only negligent but he was reckless also, because whoever is in position of danger, वही जो है जो एब्सोल्यूट लाइबिलिटी का प्रिंसिपल है, और आपका वो जो डॉक्ट्रिन है रेलैंड वर्सेस फ्लेचर का, वही प्रिंसिपल इन लोग इधर उधर मोड़ के ना बोलते हैं कि नहीं ये नेग्लिजेंट एक्ट नहीं था, ये रेकलेस एक्ट था. सो he was made liable and was directed to pay the compensation. ठीक है. So this will be too premature for me at least to comment on thermal injury. कि इंडिया में तो अभी तक नहीं हुआ है. अभी तो चल रहा है कुछ एरिया में जहाँ पे गवर्नमेंट ऑफ इंडिया wants to establish the reactors तो वहाँ पे भी लोग डेमोन्स्ट्रेट कर रहे हैं कि if something goes like that in Vizag also, in a nuclear, of course the defense department did not say, but some say nobody knows whether the fire was on the nuclear sub or not. तो ये सारे के सारे ये बारे में अगर मेरा पास इंफॉर्मेशन होता तो मैं कमेंट करता, but I'm sorry, right now I do not have that information on thermal injury. But thermal injury can cause death, dangerous death.
Thank you, sir. Thank you, sir. Over to you, Prashasti.
Yes, sir. Thank you so much, sir. Now, on behalf of the entire fraternity of Manichand Pahade Law College, I take this opportunity to propose vote of thanks. First of all, I extend my deepest sense of gratitude to our guest of honor of today's session, Professor Dr. Prabir Kumar Pattnaik, sir, for making this session a worth listening and by giving us a depth knowledge on a given topic. I extend my sincere thanks to our respected principal, Dr. C.M. Rosser, for his unflinching support. Last but not the least, I thank all the attendees on Zoom and YouTube for their valuable presence. Before ending this session, I request all the attendees to remain present tomorrow at the same time, where Professor Chirag Balyan, Sir, Assistant Professor at MNLU Bombay, will be addressing a topic, General Principles of Criminal Liability. So till then, stay tuned, stay safe. Thank you all. Thank you, sir.
Thank you, sir. Thank you, sir, once again.
Thank you so much.